So this video is going to cover criminal process, procedure and sentencing. There are always two questions at the end of the crime section on Law 02 for AQA. The first is always describe the procedure to trial for the particular matter, and the second is always to describe sentencing. This can either be factors, aims and/or the types. Remember that the types of offence dictate where the trial is going to be heard. So summary offences, for example, these are the least serious types of matters, and the trials will always be heard at the magistrate's court, for example, assault or battery. For either way offences, these are the middle ground in terms of seriousness, and they're either heard at the magistrate's court or the Crown Court. And the examples that we know are section 47 and section 20. Remember that where the trial is actually going to be heard for an either way offence is decided through a mode of trial hearing. This is where the defendant initially is asked whether they want their matter to be heard at the magistrates or the Crown, and if they elect for the magistrates, then the magistrate themselves will get to decide whether they accept the matter. Finally, we've got indictable offences, which are the most serious, and the trial will always be heard at the Crown Court. For example, section 18. In your exam, you might be asked to look at bail. You might just be asked to mention it if you're just talking about procedure up to the trial, or it might be the specific focus of the question. We don't expect it to be the specific focus, but theoretically it could be. So remember, with bail, the defendant may be bailed at the police station, meaning they're sent away until they have to appear for the first time at the magistrate's court. At this stage, when they're at the magistrate's court, the magistrate will then consider whether to bail the accused again until the date of their next hearing. Bail can be either conditional or unconditional, and there is a presumption in favour of bail, meaning that you should be entitled to it unless there is evidence that you might commit further offences, interfere with witnesses or evidence, or fail to attend court. With conditional bail, if there is a worry that the accused might do any of those things we mentioned on the previous slide, the court may decide that they need to impose conditions on the bail. Such conditions include reporting to the police station, living at the stated address, or living at the home of a relative, or they might have to live in a bail hostel, staying away from certain people or places, and a curfew, which the court, but not the police, can order an electronic tag. If there are no worries about the defendant and they're not seen as a risk by the court, they are more likely to be given unconditional bail. So let's have a look now at sentencing. So we've already established that our defendant has gone to trial and been found guilty. So in terms of sentencing, there are three things that we need to think about. Factors, meaning aggravating and mitigating. The aims of sentencing. The aims we need to look at are retribution, deterrence, prevention of crime, and rehabilitation. And also the types of sentences, including custodial, community sentences, fines, and discharges, both absolute and conditional. So let's start by looking at the aims of sentencing. So the purpose of sentencing is set out in section 124 of the Criminal Justice Act 2003, and it states that for offenders over the age of 18, the court must have regard to the punishment of offenders, reduction of crime, reform and rehabilitation of offenders, protecting the public, and making of reparation by offenders to persons affected by their offences, so some sort of compensation, making up for their behaviour. So retribution, this means revenge and punishment, and this aims to reduce crime in the future by focusing on matching the punishment to the offender. It looks at reforming the offender so that they're less likely to commit crime in the future. So for example, paying for damage caused in a case involving vandalism. It's seeking revenge for bad behaviour in the past. Deterrence, this is designed to put people off, and again it's aiming to reduce crime in the future. It may be an individual deterrent to put off that particular offender, but also more generally, it can deter all members of society. So harsher punishments will prevent the public from committing crimes themselves. So longer prison sentences. Rehabilitation. What we're looking at here is a different form of the word rehabilitation to the one that you may be used to. What we're looking at is reforming and helping people to overcome their problems to help avoiding offending again. So, for example, education and training in prisons to help a prisoner get a career rather than having to return to a life of crime. And finally, prevention of crime by protecting the public. You can say that all sentences aim to prevent crime. That's the point of them. And the offence is not able to be committed if the person is physically in prison. So it's a physical barrier to this sort of conduct in the future. So the sentences available to the court, you can choose from a large number of different offences, and they're split broadly into 4 categories. Custodial sentences for a start. These are only for the most serious crimes where no other sentence will suffice. The sentence imposed by the court is the maximum time the offender will be in prison for that particular matter. So, for example, the maximum sentence in prison for Section 20 or Section 47 is 5 years. Remember, Section 18, the maximum is life, and for assault and battery, the maximum is 6 months. Community sentences are alternatives to prison, and they're almost one rung down in terms of punishment, and they are non-custodial options available. So the sorts of requirements within a custodial community sentence would be unpaid work of up to 300 hours, a curfew to be at home at certain times, exclusions from a certain area, being a resident in a certain place, drug treatment and tests, alcohol treatment, supervision, so to attend probation, and attendance, which is 12 to 36 hours at an attendance centre, usually to work on specific behaviours. Next type of punishment down are fines. These are financial penalties. For example, you've got fixed penalties for speeding offences, or at the court's discretion, magistrates can fine somebody up to a maximum of £5,000. Remember, on a practical level, there is no point imposing a fine if the person can't pay. And discharges. This is where the defendant isn't punished, or at least they're not punished at the moment. An absolute discharge is where there is no further action taken and no punishment whatsoever, but the matter will appear on somebody's criminal record. Alternatively, the court may impose a conditional discharge, which means that you're convicted without a sentence on the condition that you don't reoffend within a specific time. If they do reoffend, they'll be resentenced for the original offence as well as the new one. So let's now move on to the final point, which is sentencing factors. So these are the elements that will determine how harsh a sentence will be based on the defendant's characteristics and their conduct. Aggravating factors will result in the defendant having a longer sentence. Mitigating factors will result in the defendant having a shorter sentence. So as we said, aggravating factors are likely to result in the defendant receiving a harsher sentence. And the sort of factors that you might want to look at in your scenarios, things like previous convictions, racially motivated offences, offences based around religion, disability or sexual orientation. Mitigating factors will reduce the sentence and can result in the defendant having a lighter sentence. So the final thing that you need to do is practice for each topic covered. You need to write yourself a short model answer, firstly about the procedure to trial, and then sentencing aims, sentencing factors, and sentencing types. Ensure that you can write the answer in 4 minutes and you give yourself a minute to apply. Make sure you refer to the defendant, you come to logical and common sense conclusions, and you don't overcomplicate things. The final point is, with sentencing, it may be that you're asked about one individually, and that will be about a 5-mark question. However, it may be that you're